But we're here every single year and have been for the past, 8 years now. We just keep doing this. He gets out, he gets on drugs, he starts threatening to kill us, and here we are again. I just want to know when it's going to end. If next time, if it's actually going to end in my dead body, as he always says.
And she knows this. She starts doing this to me anytime I try to get around my daughter when she has a dude around, and she tries to make me look bad.
She doesn't have to do anything to make you look bad. You make yourself look bad. You continue to violate court's orders. She indicated the last 8 years. It's actually been 10 years. Since I've been on the bench in 2017, this is the 8th indictment that you've been in front of me in 10 years. Case number 26-CR43504, the State of Ohio versus Justin Callers. Mr. Callers is before the court with his counsel, Mr. Clark, Ms. Tranter, on behalf of the State of Ohio. Ms. Tranter?
Your Honor, my understanding is that Mr. Callers is prepared to change his plea this morning. He'll be pleading to the indictment as charged, including 5 counts of violating a protection order, a felony of the 5th degree, as well as 1 count of aggravated menacing and misdemeanor of the 1st degree. We do have the victim present in the courtroom today who is prepared to make a statement at the appropriate time, and we are in agreement with proceeding to sentencing today.
All right, Mr. Clark, is that accurate?
That's accurate, Your Honor.
All right, Mr. Callers, they're telling me that you're going to change your plea to the 6 counts of the indictment. Before I get to your change of plea, I am required to go over some things with you, okay?
Yes, Your Honor.
How old are you?
29.
How far did you go in school?
GD.
Can you read and write?
Yes, Your Honor.
Are you a citizen of the United States?
Yes, Your Honor.
Has anyone promised you how the court would sentence you in this case?
No, Your Honor.
Has anyone threatened you in any way to get you to plead guilty against your will?
No, Your Honor.
Are you satisfied with the representation that you've received from Mr. Clark?
Yes, Your Honor.
Are you currently under the influence of any drugs or alcohol?
No, Your Honor.
Do you take medications that interfere with your ability to understand what's going on today?
No, Your Honor.
I have in front of me a document called a change of plea. On the second page, on the line marked defendant, there appears a signature. Did you sign this?
Yes, Your Honor.
Did you read this and go over it with your attorney before you signed it?
Yes, Your Honor.
And you feel comfortable that you understand what it says?
Yes, Your Honor.
This document says you're entering a plea of guilty to 5 counts of violation of a protection order with a prior conviction. Each of those counts carries a maximum penalty of 12 months in prison, and each of them carries a maximum fine of $2,500. The 6th count is one of aggravated menacing. That is a misdemeanor of the 1st degree, and that carries a maximum penalty of 180 days in the Warren County Jail and a $1,000 fine. Do you understand the maximum penalties?
Yes, Your Honor.
You're also subject to a discretionary period of post-release control, and I know you know what that is because you're in on a PRC violation right now, correct?
Yes, Your Honor.
But what that means is when you finish this sentence, when you are released, the Adult Parole Authority may supervise you for up to 2 years. If you violate that supervision, the Adult Parole Authority can return you to prison, as you found out, for up to 1/2 of the court's original sentence. If your violation is that you've committed another felony, you can be returned to prison for 1 year, or the period that you have left on PRC, whichever is longer, that time would run consecutive to any additional prison time that you get sentenced to. Do you understand that?
Yes, Your Honor.
You are presumed innocent of these charges. You cannot be sentenced or punished unless you plead guilty or you're found guilty following a trial. Do you understand that?
Yes, sir.
You have the right to trial by jury. If you want, we will impanel a jury of 12 people and require the prosecutor to present sufficient evidence to convince each of the jurors of your guilt beyond a reasonable doubt, or the jury is required to find you not guilty. Their decision must be unanimous. Do you understand that?
Yes, Your Honor.
At that trial, you have a right to see and hear all the evidence that the state has against you. With the help of your attorney, you have the right to confront and cross-examine each of the state's witnesses. Do you understand that?
Yes, sir.
You have the right to call witnesses on your behalf and in your defense. If any of those witnesses are reluctant to come, the court can force them to come by way of subpoena. That's your right of compulsory process. Do you understand that?
Yes, sir.
You have the right to remain silent at your trial. You cannot be forced to testify against yourself. The prosecutor is not permitted to call you as a witness. You can choose not to testify in your own defense. If you don't testify, that will not be used against you, and I will instruct the jury that they are not permitted to infer your guilt nor anything from your silence. Do you understand that?
Yes, sir.
The burden of proof is on the prosecutor. At your trial, you're not required to call any witnesses nor present any defense, and if you do not, that will not be held against you. Do you understand that?
Yes, sir.
The standard of proof is beyond a reasonable doubt. That standard applies to each of the essential elements of each charge from the indictment. Do you understand that?
Yes, sir.
Now, you could also waive your right to a jury trial but maintain all the other rights we've discussed. You could try your case to the court. I too would have to be convinced of your guilt beyond a reasonable doubt, or would be required to find you not guilty. Do you understand that?
Yes, sir.
Do you believe you understand each of these rights we've discussed?
I do.
Do you understand that when you enter a plea of guilty, you'll be waiving all these rights? We will not have a trial.
I do.
Do you understand that the plea of guilty is the complete admission of your guilt, and the court would be able to proceed directly with judgment and sentence?
I do.
This is how you wish to proceed.
Yes, sir.
Ms. Tranter?
Your Honor, in addition to the facts alleged in the indictment, these incidences occurred in January the 7th, 8th, 13th, 5th, and 15th of this year, 2026. The defendant made multiple text communications as well as jail calls to the victim in this matter, including threats to kill her. She did have an active protection order against the defendant at the time, and he has been previously convicted of a prior TPO violation.
Mr. Clark, anything on those facts?
Nothing on the facts, Your Honor.
Mr. Collins, did you hear the statement that she read?
I did.
Do you admit that what she said is true?
I do.
And again, you understand all the rights you're giving up when you enter a plea of guilty, those rights we discussed?
I do.
What is your plea?
Guilty.
The court will make a finding that you've made a knowing, intelligent, and voluntary waiver of your constitutional rights. The court accepts your plea of guilty, and based upon the statement of facts in your plea, the court will make a finding of guilty. And it's my court's intention to proceed directly with sentencing. Anything on behalf of the state?
Yes, Your Honor, Ms. Cullors is present and would like to address the court.
State your name for me, please.
Nicole Colors.
All right, and what would you like me to know?
I think he's just pleading guilty today in hopes that he's only going to get an 18-month sentence, which would be great if he would stop doing this. But we're here every single year and have been for the past, 8 years now. We just keep doing this. He gets out, he gets on drugs, he starts threatening to kill us, and here we are again. I just want to know when it's going to end, and if next time, if it's actually going to end in my dead body, as he always says. So he can shake his head all he wants, but he's hurt me before, he's put me in the hospital before. It isn't like just an empty threat.
Anything else you want me to know?
I just hope he gets more than 18 months, because after 85%, and then that knocks it down to 12 months, and then his good time, he only serves 9 months.
That I don't know where you're getting those numbers. That's not accurate. Those numbers aren't accurate.
Last time he only served about 12 months. He got out, and then here immediately he started violating again.
Okay. All right. Thank you.
Thanks.
Anything else, Ms. Tranter?
Your Honor, we are just asking that the court impose an appropriate prison term to hopefully give Mr. Cullors a wake-up call. This is a situation, as the court knows, has been going on for a long time. Unfortunately, the state of the law at this point, as we have discussed, only allows for felony of the 5th degree to be filed in these instances, but we do have 5, potential of up to 60 months, so we would ask that the court impose a relatively high prison sentence on Mr. Cullors.
Mr. Clark, anything?
Your Honor, as far as sentencing goes, I just wanted to proffer to the court. There are 5 different protection order violations, but only 3 dates for these violations, meaning we're going to argue that they should be treated as allied offenses of similar import, and that his max sentence should actually only be 3 years, what he's facing. We believe that an 18-month sentence is half of that and more than fair to punish him. He has recently taken responsibility seemingly for these actions, and by that I mean by his actions, what he's doing in prison to try to improve his mental health and drug issues in the past. He is enrolled in the BIP drug and alcohol program. He's been in that for about 2 months. That's a 6-month program. He is taking a fatherhood class. He's about 3 to 4 weeks into that, which is a 2-month total course. He's in an anger management course, which he's completed about 2 to 3 weeks of. and that is a 2-month total course, but it can continue as long as he needs it. We just asked that the court sentence him to 18 months or less. Again, these are these violations specifically. I know he has a track record with this victim, and I understand that she's upset, but these violations specifically were jail calls and were seemingly text messages. So, these violations are not, no physical harm was caused or anything to that effect. Obviously, he would acknowledge that the messages weren't appropriate, but I did want to at least acknowledge that in front of the court. So,
Thank you. Mr. Cullors, is there anything you want me to know?
Yes, Your Honor. I would never hurt her, and she knows this. She starts doing this to me anytime I try to get around my daughter when she has a dude around, and she tries to make me look bad. And look, I've been in front of you multiple times, and it's all been for phone calls and this and that. You know what I'm saying? And if you look at some of these phone calls, yes, I was on drugs at this time. I've been trying to really get help this time and trying to better myself, so when I get out this time, I can actually get my daughter's life so she can quit doing this. Because every time I get out and I try to get in my daughter's life when she don't want me around, then she goes and she does this, and then I get upset and I get on drugs, and then it's just a revolving door. You know what I'm saying? I don't want to keep doing this. You know what I'm saying? So I'm actually trying to do something different this time, because I'm not going to hurt her, and she knows I'm not going to hurt her. I don't want to keep doing this with her. So I'm actually trying to do the right route. So this is why I'm trying to take steps while I'm in prison, so when I get out, I can go and take the proper steps, get a lawyer so I can get rights to my daughter, so she can't keep doing this to me, so I can go the actual right way this time instead of trying to go through her.
All right, thank you, sir.
Yep.
I just took a few comments before I pronounce your sentence. Mr. Cullors, she doesn't have to do anything to make you look bad. You make yourself look bad. You continue to violate court orders. She indicated the last 8 years. It's actually been 10 years. Since I've been on the bench in 2017, this is the 1, 2, you have 3, 5, 6, 7. This is the 8th indictment that you've been in front of me in 10 years. 8 indictments. You're probably, of all the defendants, thousands of defendants that have come before me, the number of indictments that you have is probably pretty close to the top of the list. I don't have many, there's not many defendants that when I hear the name, I immediately recall the case, because you've been in front of me so many times. That's why I don't need a pre-sentence investigation today. I understand these are felonies of the 5th degree, and Ms. Cullors, I will say to you, it doesn't matter how many times he does this, the level of the offense never changes. It doesn't go up any higher than an F5. I would suggest, if you don't like that, and I don't care for it, domestic violence charges, they escalate, they go up to F3s. Unfortunately, this violation does not go any higher than an F5. Under an F5, there's a presumption that he gets community control. Were you aware of that? I'm sure Ms. Tranter's told you that this is what's considered a low-level felony. But I share your frustration. Mr. Cullors doesn't seem to have any respect for the court's orders. You are ordered to have, she has a protection order against you, and you seem to think that you don't have to follow those orders. You know I've sent you to prison before. This isn't the first time, and it's going to happen again. So the court has considered the statements made here today, the purposes and the principles of sentencing, the relevant seriousness and recidivism factors. The court will note for the record that this is your 1, 2, 3, 4, this is your 5th indictment for violation of a protection order. The court has considered the defense's argument with regard to merger. The number of days doesn't matter, it's the number of contacts. Different contacts on the same day would be separate violations. So the court does find that these are not allied offenses of similar import, and all of them will stand. The court further finds that probation obviously would not adequately punish you, and it would seriously demean what happened in this case. Prison is necessary to fulfill the purposes and the principles of sentencing, including punishment, deterrence, and protection of the public, in this case Ms. Cullors, due to your prior extensive criminal history, due to your prior failure to respond to previous community control sanctions. You just don't get it. And I will say one more thing, because you're going back to prison today. If you come before me on another one of these charges, I don't care whether you enter into a plea bargain with the state or whatever it is, however many counts that you have, you're going to get 12 months on each count, and each count will run consecutively. You understand me? So if you call her 4 times, you're going to get 48 months. If you call her 6 times, you're going to get 60 months. I'm just not going to do this with you anymore. So either you stop calling her or just suffer the consequences. A plea bargain is not going to help you in the future. And I know Ms. Tranter was very firm in this case that she was not going to agree on a number. It's going to be more than 18, I'll tell you that. So with that, the court's going to order you on count 1 to serve 12 months in prison. On count 2, the court's going to order you to serve 12 months in prison, that to be served consecutive to count 1. Counts 3, 4, and 5 are each going to be 12 months, and all of those will be served concurrent with count 1. So you have 24 months. Count 6, you're going to get 180 days in the Warren County Jail. That by law must be served concurrent with the felony sentence. Now, you're also subject to the discretionary post-release control. Do you want me to go over that with you again?
No, Your Honor.
All right. There may be opportunities for you to receive up to 1 day per month for participating in certain programs sponsored by the Department of Corrections. You do have a right to appeal the court's decision of your sentence to the 12th District Court of Appeals. If you want to appeal, you must file your notice within 30 days of today's date. If you can't afford to pay for the transcript or anything necessary for your appeal, including an attorney, that can all be provided to you at no cost. The final thing is the court does find that a consecutive sentence is necessary to punish this defendant and to protect Ms. Collars. It is not disproportionate to the conduct or the danger posed by the defendant. And again, this defendant demonstrates that he's just going to keep doing it, but 2 or more offenses are part of a course of conduct, and the harm caused is so great or unusual that a single prison sentence is simply inadequate regarding the seriousness of the conduct. Ms. Tranter, indigent for the purpose of any fines, costs, or other financial sanctions, 0 days jail time credit on these 24 months. Ms. Tranter, is there anything else?
No, I think that covers it, Judge.
Mr. Clark?
Nothing further, Your Honor.
All right, that's all. Thank you.
Thank you.